Good morning. On behalf of MGM School of Physiotherapy and MGM Omics Research Center, Navi Mumbai, I welcome you all on the occasion of World Intellectual Property Rights. As rightly said, innovation is the necessity for the humankind. So, apart from innovation, the inventee and the innovator both are supposed to also know their rights and patent. So, on this day, we have invited Mr. Chirag Tanna sir, who is the Director, Patent and Trademarks at INCDIN. Sir is also the founder of co-founders team where he is responsible for the intellectual property rights and patented inventor. I welcome you, sir. And sir will be delivering a talk on importance of intellectual property rights in healthcare industry and medtech industry. Thank you.
So I am a biomedical engineer by education. In our field of science and technology, the majority of tryst or the majority of things that we will come across is patents. So in this case, an engine, shock absorbers, anything where science and technology gets involved, where functionality is involved, where utility is involved, all that gets protected under the patent regime. So form, design act, function goes under the patent regime. One of the largest case studies you must have read across the world, Apple versus Samsung. So they were not fighting about technology at that point in time. They were not fighting about what happens inside an iPhone or what happens inside. The entire war, which happened for 7 years, which was covered, right, went from all the way to Supreme Court in the US, was a simple thing. What Apple did was it removed all the buttons. It took a phone. It made a rectangular phone with rounded corners and one button. So it was the form factor that Samsung copied. What happened behind the scenes is a separate story, but the form factor should not have been copied. Some simple form factor. Samsung maybe could have come out with a different design, maybe not rounded corners, but they chose to infringe on the design aspect of what Steve Jobs and Steve Wozniak did, and that is why they were sued. And they did it across, right? They did it right from they did it from their phones to their the tablets, everywhere they infringed. So something as simple as designs where just the form is protected can also become massively huge, as we saw in the Apple versus Samsung story, right? So these are the 4 major verticals that we see in the IPR regime. Because we are in the realm of science and technology, I will talk about patents a little more. But why did IPR come into being? As I told you, right? IPR, intellectual property rights, intangible in nature, far greater value than physical assets of any company. Take any company in the world, from as simple as something like Coca-Cola, which may or may not have patents, but their brand value is far significantly more than the physical assets that they own. Something like McDonald's, their brand value is far more than intangible assets, so trademarks, far more than the physical stores that they own in value, right? So there were various justifications. Why did IPR? Because we are on World IP Day, we must talk about why did this thing come into existence, right? So there are 3 known justifications. One is, if somebody is spending time, effort, money into time, effort, and labor into it, they must get a reward in return. So that is the economical justification, the second justification that you see. The ethical justification is somebody is spending that is the ethical justification. Economic, somebody is spending money on it, they should get something in return. And this entire justification of doing something and getting monopoly in return, that is what all the intellectual property rights is about. That you do something, contribute to the development of society, whether it is patents, trademarks, copyrights, designs. You contribute to humanity, you contribute to society, and in return, you get a reward, where the reward is that you get to squat on it as a monopoly. How much time you get to squat on it depends on the vertical. So patents, for example, you get to squat on it for 20 years, monopoly. Trademarks, you can own it for life as long as you renew it every 10 years. Copyrights, you can own as long as you are alive, plus 60 years. It goes to your heirs also. Designs, 10 to 15 years. So there is a finite life after which the public can easily enjoy your property without paying you royalty. So that is the reward that you get in return for disclosing. If you don't disclose, then what happens? Then it goes beyond intellectual property rights. Then it goes in the domain of trade secrets. That you don't disclose, you don't get protection. If you disclose, you get protection. How you get protection, that is left to the courts, right? So you have to trust the judicial system for that. In a country like India, that becomes tricky, but I'll come to that later of how that is also solved. And then there is empirical justification. Empirical justification is very simple. It says if something is happening for a long time, we should not touch it. We should just muddle through. That's the safest thing. Something is happening, don't touch it. Law of inertia. Let whatever is happening, let it happen. But the whole world has adopted this system, right? There is no country in the world which says that, come and everything is free in our land, whether it's a capitalist country, whether it's a socialist country, communist country. Every country in the world has this intellectual property rights system. Intangible in nature, far higher in value, but it exists. And this is what sets the pace of development of a nation. Now, this development of a nation is also something that I will talk about a little later. But remember what I said. So I said of these four, because we are from the science and technology background, and because you are in the medical domain. So in medical, there are two verticals again, products and processes. In products and processes, there are mainly pharmaceutical drugs, which aid and assist people to live longer, and support devices and softwares, which also aid the entire system or doctors to help patients live longer or help them have a better quality of care and life, right? So as researchers, if you ever embark on the process of researchers, and you will, if you become surgeons and all, you will see that there are the medical device things that are out there are never enough, and you constantly want to evolve. And I say this from an aspect because biomedical engineering, as I said, I am a biomedical engineer. There's something close to my heart, and we are at a stage right now where we are closing the loop of whatever we have protected. We are now selling it to the Western world. We are selling it to the Eastern world, less developed countries than India. That is where we have reached. So if you invent, you should know how to protect. And how do you protect? So three things you should remember. Are you solving a problem, technical problem? Are you bringing an advantage that the entire world has not seen? And what is your solution towards solving that problem? If you can answer these three questions, then you can get a patent in return for it. This has to be global in nature. You cannot say ki in India, this has happened for the first time. Why? Because science does not have geographical boundaries. You cannot say that this is science of India, or this is science of Pakistan, or this is science of Bangladesh, or this is science of USA. Science does not have a geological tag to it. Protection that you get has a geological tag to it. So if you file a patent in India, you will get protection only in India because courts have jurisdictions. So Court of Delhi will not be able to stop somebody from infringing in China or somebody from infringing in Singapore. So the test of patentability is universal in nature. The problem that you are solving has to be universal in nature. The advantage that you are solving has to be universal in nature. And the solution that you are solving has to be universal in nature. Why? Because you do not want to reinvent the wheel. If the wheel is already there, maybe you have never heard of the wheel, but it exists. There is documentation of the wheel existing. Just because you may not have read it, it becomes new, but it is not inventive. And if it is not inventive, you cannot have a patent around it. So if there is any document, dated document in the world, which talks about what you are proposing to invent or you are proposing to protect, that can be used to defeat what you are protecting. So all these three things have to be global in nature, right? Tests, as I told you, right? WIPO is the International World Intellectual Property Organization in Geneva, is the international body which overlooks what is to be patented. So the whole world has defined how do you define, what is an invention? ठीक है, technology problem हो गया, technology solution हो गया, technology advantage हो गया. But how do you, when it goes to the patent office, how do they evaluate it? So there are three tests that the whole world has defined. Okay, novelty, inventive step, industrial applicability. Number 1 and number 3 are very, very easy. Is it new or not? Very easy to establish. Utility, also very easy to establish that it is replicable across the universe. Nothing will change. Every day since the last 100, 200 years, what is argued even today at the patent offices, at the courts of law, is it inventive? And why is it argued? Because once, so remember the philosophy, right? You present to the world what you have invented. Now that people have read it, and the classic adage goes, hindsight is 20/20. The moment people read it, they start to feel it is obvious. But start to feel is not a tangible way to evaluate something. We need a mathematical way to evaluate what is inventive step. So tests, these were the tests, but then there were separate tests developed to test what inventive step is. And that is what is argued in courts day in and day out. But that we'll touch that later. But one of the simplest things is, let's say your invention is A plus B plus C. Some document in the world in China says, okay, A plus B was known. Some document in Egypt says B plus C was known. And some document in US says A plus C was known. You were maybe the first person to bring them all together and convert them to A plus B plus C. Okay, so you have novelty, it has advantage, all of these are there. But somebody else also could have done it. they did not do it is a separate story. Why they did not do it? Maybe they did not have money for it. Maybe did not have the business acumen for it. Maybe there was no need for it. But if they could have done it, then it lacks inventive step. If it lacks inventive step, you are failing the second test of patentability and you then get a patent in return. Which is why you have to then show the patent office, okay, A plus B was known, B plus C was known, A plus C was known. But I brought in my brain. Finally, intellectual property right now, you need to show that what did your brain do to bring these things together. They check for synergistic effect. That you added B dash, because of your B dash, now these things are talking to each other in such a manner that you are getting a synergistic effect. What does that mean? That now you are getting an advantage which is significantly known. So leap of faith. You're getting significantly known or a shocking result that was previously not possible. And that only happened because your brain created some intermittent system or an algorithm or a technology in between that now these things are talking to each other in an exaggerated manner, right? So simplest example, if you are aware of how a car works. So even in a car, you put 4 wheels, you put an engine, it becomes a car. But one aspect you add that evolved over the years, a differential gear was added, which allows different rotation of wheels on the left side and the right side as the car is turning, so that there is less friction and less, it turns easily. Now that is the B dash that they're talking about. That is the invention which now allows the car to move homogeneously and turn easily, right? So B dash is always that you have to remember that what did your brain contribute? What did the world do previously? What did your brain contribute? And has to tie up with the advantage. Okay? Problem, solution, and advantage. So B dash say you should be able to show that now because of my B dash, A and B had X percentage output, B and C had Y percentage output, A and C had Z percentage output. Now because of B dash, my output is not X, Y, Z. My output is X, Y, Z plus some factor that increases X, Y, Z as a surprising result. I don't know how that happened, but it happened because of B dash. So that is the inventive step that the patent office will always hunt for. If they fail, that is what you present to the patent office, that this is the inventive step and this is why it is an invention, right? Another question that we keep asking about concept versus can ideas be patented? Can ideas be owned? Ideas cannot be owned in any form. Something as simple as brands. If you have an idea of a brand, you need to write down what that brand is. If you have an idea of a concept in the creative realm, for example, I gave you the J.K. Rowling story, right? The idea was very simple, that there was a wizard who had lost his parents, there was a school setting, there was Lord Voldemort, there was a villain. But the moment it got converted or enabled into a book format, somebody wrote down 7 volumes of stories around it. Now you have enabled that idea. Now that you have enabled that idea, it becomes a copyrightable matter. If you make a movie out of it, same concept, but you have enabled it into a movie format, it becomes a copyrightable movie. Similarly in patents, concept of flying. Let's say, what did the Wright brothers do? They enabled us to fly, right? But concept of flying was known. They don't own the concept of flying. They don't own all perpetual rights of aeroplanes all around the world. They did 2 things. They did sustained flight over a long distance. The most important thing they did was they studied birds and they figured out one mechanism, that B dash, of how do you change path mid-flight. Now, what is the point of flying in a straight line? You will never reach wherever you want to reach. So you should be able to change course mid-flight. So they invented a device which brings in instability and then which allows the plane to bank as and how you want. Now that enabled the device, the mechanism of flying. And that device is what they own. And you could then have had various devices which enabled those, and you can have separate patents around it. But one version of flying is what they own. They didn't own the concept of flying. Take anything, take any invention, right? From data transmission, concepts cannot be owned. One way of enabling those concepts, one or more ways, whatever your mind can produce, you can own that concept, right? So you can never have a blanket protection over a concept. It has to be enabled and written down into a product or a process. And why do you own something? I told you, right? The idea was to own a piece of property because everything is intangible in nature. It is a product of your mind. You pen that down into, so you see my firm's tagline. My ID means, in French means idea. The tagline is ink your idea, that whatever is in your thought, you pen it down. If it is a brand, you pen it down, submit it to the patent office, you get a trademark in return. If it's a creative concept, pen it down, you get a literary work copyright protection in return. If it is a painting, paint it, you get artistic work protection in return. If it's an invention, do the invention, write it down in a particular format that the patent office wants, technical solution, technical problem, technical advantage. They will assess it and you get patent rights in return. So you need to pen down your idea and you get certificates in return, which warrant what you own over the over that intangible property, right? And it has impact, right? Right from time immemorial, right? Whoever files wins. That is the bottom line. Who invented the telephone? Tell me who invented the telephone. We have studied this since our second standard. Who invented the telephone? That is what we all know. The truth is, if you read, just Google who invented telephone or just Google Alicia Gray versus Graham Bell. There was one guy, Alicia Gray, who was getting far more better results than what Graham Bell was getting. It just happened that Graham Bell was getting very inferior results, but Graham Bell was always keeping a watch on what his nemesis, Alicia Gray, was doing. Alicia Gray got superior results. We went to the patent office to file his patent application. It was lunchtime then. Graham Bell got wind of it that Alicia Gray is going to file his patent. Graham Bell also reached the patent office that same day, same lunchtime, and bribed the clerk to get his patent filed first. First to file always wins. First to invent or first to create, first to produce does not win. That is the mantra all throughout history. We will see. The truest inventor is Alicia Gray. Did not file the patent first, or Graham Bell ended up filing the patent first. That is why the whole world credits Graham Bell with the invention of telephone. But you take anything, right from telephones to automobiles to flying to today's social media, you will always see that there are at least two people who are neck to neck in the race. There was an entire series on Amazon 5-6 years ago, which talks about this duality of people who are racing ahead. More often than not, it was people like Alicia Gray who were ahead, and then more often than not, there were people like Graham Bell who filed first, and the history knows of them more than who actually created the things first. Why IPR again is important is Microsoft biggest example, right? Startups were protected, their rights were protected right from their inception in the garage days. So when Bill Gates got his first order from IBM to create a DOS-based working program, BASIC. His father was a lawyer, not a patent lawyer, not a copyright lawyer, was a lawyer, and told him, okay, give it to IBM for $85,000, but retain the copyright with you. Retain the copyright of that program with you. And Bill Gates negotiated the deal in such a manner that they retained the copyright, and that formed the basis of Windows first version, Windows 3.1, Windows 95, 96, 99, to the largest company in second largest, maybe, or the largest right now after Apple in market value today. So foundations of growth you will always find in intellectual property rights. And then where do because we are at the university now, and I'll talk about that later also. Foundations of intellectual property rights also you will find in a lot in research universities and universities across the world, right? Similarly, in the Apple story, in 2001, Steve Jobs had to pay around $200 million when they introduced the iPod to a company in Singapore called Creative for rights infringement. That time, they were not very gung-ho about protecting their intellectual property rights. Today, they have reached such a stage that everything that Apple does, right from the box your phone comes in, to the manual that it comes in, to the Apple stores, to the staircase of the Apple stores, to the Genius Bar, everything under the sun that Apple does is protected by patents, trademarks, copyrights, design registrations. They do not, nothing gets shipped out unless there is a proper intellectual property right system in play. Right. Now I'll shift some gears. I'll give you two contexts, So this was a little bit about IPR, but then IPR and health tech and IPR in today's world and where we are or what are we doing. I'll just talk about that a little bit. So two contexts I want to build in. So remember these 2 days. So remember these two dates, 1790 and 1970. And why, because suddenly, I don't know if you have noticed, as a country, what are we talking about? We are talking about 75 years of independence. We are talking about Amrit Kal of the next 25 years. And while those are jargons, what are we talking about, right? We are talking about a developed nation by 2047, right? So I am 40 years old. Throughout my life, I have heard that we are a developing nation, we are a developing nation. And always I have wondered, okay, when will we be a developed nation? Or how do you evaluate that we have become a developed nation? And I'll give you that answer at the end. From an IPR perspective, how do I look at things of whether we are a developing nation or a developed nation? But these two dates are important because 1970 is the Indian Patent Act, when India started protecting patents as a regime. 1790 is the most developed country in the world that we know, United States of America. Their Patent Act goes back to 1790. So a country like that has a leap start of what? 100, 200 years more than you. They have that genesis of ecosystem with them, of having advanced civilization and having the regime to protect it, while we just took birth in 1970, right? So these two dates are important, that context. The other context that I will set is, what is the India story right now? Again, as I said, right, we are talking about a lot of things. We will see now that we are going up to a massive election which has already started. India was known to be perennially slow in everything. We know how our judiciary system is. So patent offices they don't go to courts. You know how the Patent Act world works is, so WIPO is there. Then there are patent offices, trademark offices, copyright offices, design offices under the central ministry. But these are called quasi-judicial bodies. So you don't have to take your patent and go to court and argue it. These go at the patent offices. They are there in every metro. There are officers there who evaluate your patent application. And then if it gets to grant, they have the authority to grant you. And then if there is infringement, then you go to court. You don't go to court right away. So I don't have to go to court. I am not a lawyer per se. I am licensed to practice patents and trademarks. So there was a lot of backlog, and there was no incentive. Trademarks used to take 4 years. Patents, my own patents, which I filed in 2011, got granted after 10 years. So where was the motivation? So last year, in one swift stroke, what the government did was hired 700 people, cleared almost all the backlog, and we are now one of the fastest regimes in the world in terms of all 4 verticals: patents, trademarks, copyright, designs. Not even Singapore. I practice in Singapore also. Not even USA. None of those countries have reached this level. So we are currently the fastest regime in the world in terms of intellectual property rights. Problem of quantity we are addressing as we speak. Problem of quality maybe we'll address later. One problem at a time. So the Indian Patent Office granted 1 lakh patents in the last 1 year. It is one of the most cost-effective regimes in the world. Filing for any form of intellectual property right at the government fees are extremely negligible. And yet it is a profit-making company. It's 100 crore plus revenue-making office, the patent offices and trademark offices. And again, I told you about courts, right? Finally, we think, okay, who will go to court and property rights? I don't know if any of you had your tryst with property rights or you heard from your elders. Property rights in India can take 3 generations to solve. But intellectual property rights can get solved in 1.5, 2 years maximum. We have one of the fastest dockets in the world in Delhi, which is at par with world standards. Very strict. It is actually only located to Delhi, but I'm hoping that other jurisdictions will also follow suit. Right. So some of the brilliant minds, brilliant judges proactively work on enhancing the IPR regime in India as well. Right. Other context is the global. So these are just numbers of where we are in the health tech, medtech space. This is the demand that is there out there. So if any of you are going to step out of practicing and enter the realm of, which many doctors have done, enter the realm of product development or pharma development, then this is the world that we should talk about, of what is the demand out there. And to meet this demand, now there are, obviously I told you, right, origins of research is in universities, a lot of it. And why I say that is because, remember this act, or maybe later Google this act called Bayh-Dole Act. So in 1980s in USA, what was happening was, most universities are federally funded, which means that money comes from the government and they sponsor these universities, and then they research happens there. And what happens to that research in India? It gets locked up. In US also used to happen in the 1980s like that, because that time the obligation was, if government is spending money on you, everything goes to the government. So there was no motivation left for anybody. They introduced the Bayh-Dole Act, where they said that, okay, if inventors and universities are participating in research, even if it is government money, universities can own that IP, and then they can translate it to academia, and then they can translate it to industry. And this changed. So less than 5% of inventions then were being commercialized. But in last 30, 40 years, because of the Bayh-Dole Act in the US, there was a behemoth 100 times over. They started capitalizing on the IPs that were generated in that regime. And why? Because so in the startup world, you will see today that I work with a lot of startups. We handle a lot of startups since the last 10 years. I have seen startups go from, I've seen at least 2 life cycles of startups go from 0 to 100, which earlier used to take 7 years for a startup to go from 0 to 100. Now it takes 5 years. Now with the AI revolution that you're seeing, it will take less than 3 years, because everything is available for you to plug and play. You don't need money to buy servers anymore. You don't need money to host your domain. Every cloud credits are given to you free by everyone. You don't need designers to work for you. Systems like Figma, Canva, everything available for you free to practice. So plug and play modules are available. The point that I want to build here was IP attracts investors. That is why IP is important. Whether you litigate about it or not, whether you go and stop somebody from infringing, that is just the final 5% of it. But 80-90% is the optics that IP provides. Whenever there is a startup, the first question that investors will ask is, show what you have filed. They will maybe not get into the depth, or maybe they don't have the wherewithal to get into the depth of the quality of that IP. But the presumption, the optics, the IP is filed, something cool is happening here. That is enough. So IP attracts investors. Which brings to this whole question of whether IP is a myth, whether it's a buzz, whether it's a giant. And I gave you the justification, right? Why IP was there. There is economical justification, there is ethical justification, there is empirical justification. But after doing all of this, you finally have to spend money, right? IP spend will always come before you commercialize something. So it is an R&D expense. Whether to embark on the journey or not is always a question. So the question number one is it a myth? Is it a buzz? Is it a giant? Or what is it? Do we have to act? Do we have to enroll it, or do we have to enter that domain, or is ignorance bliss over here? So there are some examples of real case studies that I will give you. What are the different types of companies and how IP plays an important role? Quickly, I'll run through these slides. So there was a company, this was one of our clients, Praxify in Pune. They started doctor-patient interaction apps in a very intelligent manner. So they started recording. What was happening initially, people would remember, you would almost always, now that culture is going away, but you would go to a GP. And why would you go to a local GP before going to a specialist? Because a GP would know your entire history from 2 generations ago. Not recorded maybe, but in his mental map, that is there. That history was very important in diagnosing or giving you a recommendation of what is to be done earlier. All that was started digitally. So this is a doctor-patient interaction where you have to protect something or where you have to record something. In India, it's still not relevant. In the US, doctor-patient interaction is very, very important, because unless a doctor records everything, they will not get money from the insurance. So what was happening in the US was a doctor was spending time just writing everything while the patient is speaking about their signs and symptoms. The doctor is not making eye contact, and it's a very wrong practice, right? So to solve that problem, there's a company in Pune who started a company. It went from a 3-member team to a 150-member team, finally was bought out for $63 million by a US listed company. This is the most perfect way of how an Indian startup judicially spends on intellectual property rights. So 5 patents in India, 5 patents in USA, and they were picked up for the IP that was filed. If this was a US-based company, something like Fitbit, US culture is file everything left, right, center. And there are monies that investors pour into it. So something as frivolous as Fitbit. Why I say frivolous, Fitbit is frivolous is because that I'll come to later. Not real medical technology, but has a portfolio of 329 granted US patents. Maybe they are of no value, but what happens is when you have such a large portfolio, if tomorrow you want to enter into the domain of wearables like Fitbit, You will have to spend money or spend on somebody like me to evaluate whether you are infringing those patents or not. So there is an automatic moat that is built around your startup. That is typical Silicon Valley culture. So two ends of the startup regime. Third axis is the biggest players. I gave you an example of Apple, right? Everything in the world they will protect. IBM has figured out a brilliant mechanism of what to protect, what to park away, what as secrets, what to publish as research rights so that nobody else protects it. In 2019, IBM reached a record of 9,000 patent grants a day, which means if you divide that by number of working days, it means 30 patent grants a day for one single company. To get to 30 patent grants in 2019, considering time lag, they must have filed at least 90 to 100 patents in 2015, 14, 16. That is the bulk of innovation that happens in a giant like IBM. That is the typical large level culture. Outside of this, we can leave this. There are companies which only do intellectual property rights. They don't do any product development. They form intellectual property rights. They try to license it to industry. If the industry is not using it, but they are infringing, you can make monies out of it. Largest example in the world, this happens more or less only in the US, because remember the date of 1790. They have that much history of data behind them where they have reached a level where they can figure out how infringement happens, what money should be extracted, and all those things. So something like Vernatex, if we are using iPhones, Vernatex 4 patents are there in every iPhone in the world because their encryption technology is used in FaceTime. And more or less people buy iPhones because of the encryption level that it provides, apart from the security and apart from the ecosystem and all those things. So these guys had 4 patents. They sued Apple, got hundreds of millions of dollars out of them. Ringo, the last one, they were the original inventors of AdWords. Why is Google gives you, now they have started charging you money. But up until 2 years ago, everything that Google was giving you was for free, right? So why was it giving you free? They had to make money somewhere. Their search engine was also free. Their search engine used to capture data words, and AdWords was the program which companies used to bid on to show you relevant ads when you were searching. That entire AdWords algorithm was what Ringo built, and Ringo, I think, got $1 billion out of it. No product, but they got monies out of their IP. Smart Flash are the guys who brought in digital rights management. What does digital rights management mean? Is iTunes. iTunes was a game changer which catapulted iPhone to where it is today. There is an app store. Money that you pay on the app store gets equally distributed to Apple and the distributor. That ecosystem of digital rights management. You pay and you get Netflix, digital rights management. You pay for that content and you get content in return. That is what was built in by Smart Flash, and they got some $300, $400 billion out of it, 533 billion verdict against Apple, right? So this is pure IP pay culture. And I'm sure you must have all heard about Elizabeth Holmes from 2004 to 2019, where she got convicted for 15 years. She figured out that fine gap where the theories of intellectual property rights end, where trade secrets come into play, and where the fudging of practical reality, fudged lines of practical reality start. So that middle ground she played for 15 years. There was no invention there. There was no product there, but she made billions of dollars in investment she got. And for 15 years, she played out that con. And the flip side of that con is, okay, the product was fraud. Everything that she did was fraud. But their patents get granted even today. In 2021, also, patents get granted, which means that it was plausible, but it just didn't become possible in the real world. So that is an outlier. And the other is the aspirational culture. I told you about the Apple versus Samsung, right? Samsung also could have invented something, but they did not. Like Apple did something so revolutionary that companies like Motorola and Nokia flipped overnight. They had to shut shop. Same thing could have happened to Samsung. Samsung was not in the, I mean, it was in the mobile game up until then, but I don't think it was the dominant player until then. They started copying everything that Apple was doing. And then eventually they had to pay only what, 300-400 US dollars even after copying and dragging on the court suit for 7 long years. But that helped them in the copying journey. It helped them or it inspired them. Today, everything that even Apple, the OLEDs that they use, the original LEDs that they use are everything is owned by Samsung. Even Apple today has to license one component. A patent has at least 1,000 plus. A phone at least has 1,000 plus patents under it. But one aspect of it, Apple today has to license from Samsung to cover this. Right? So the question again in the startup world, second question is now, I told, right, you have to always spend before, if you are in the startup world, you always have to spend more before you start getting return. Can you judiciously spend something? So this was a mind map that we developed. A company or a startup goes through 5 phases. Product development, problem. First you define the problem. Then you figure out the state of the art, what others are doing. Then you invent, innovate, start implementing. And then you start doing sales about it. Then you pivot or you do sales about it. So there is a way to protect or prevent your spend. So in patent world, there is something called as provisional patent filings that you can do at the initial stage. The moment you think that there is a light bulb that has sparked and I can make money out of something that my brain has created and something I'm solving a unmet need that the world wants, that is where provisional filings come into play. And then as and how you have more money from either your company directly or from the investors, you can then start deploying in various other countries. So I told you, right, tests of patentability are global in nature because science does not have geographical boundaries, but where you want protection is global. So if you file for a trademark in India, you will get protection only in India. If you file for a patent in Singapore, you will get protection only there. So that again comes at a later stage of deployment and acceleration. That is where you figure out, because everything is going to cost you more money. Because in India, it's cheap. The moment you go to US, it is hundreds and thousands of dollars. In every country, which is an advanced country where the conversion ratio is high, the spend also becomes equivalently high. Right? So what is India's contribution to healthcare, right? I don't know if you're aware, but we are known as the generic superpower of the entire world. Like, why? Because we have something called as Section 3 in the Patent Act. Section 3 in the Patent Act is actually in consonance with what WIPO decided. US violates it, but because it is a country which bullies everybody else, they make people believe that we are in the wrong and they are in the right. Entire South African region, entire Latin American region is alive because of what India does legally, is we make generic pharmaceutical drugs, life-saving drugs, and then supply them to these countries where they are not patent protected. One of the biggest examples was March 2012 decision, where Bayer's they have a drug which helps you manage liver and kidney cancer, and the price point at which they were selling was at $9,000. In the US, it is okay because nobody pays for it. Even it's not that the per capita income of US is that high that they can afford a $9,000 per month drug. But insurance companies pay for it and you pay premium to the insurance company. In India also, they started selling it at that price point, 2.8 lakh rupees a month. Who is going to afford 2.8 lakh rupees a month? And then there are 3 sections here. In the Patent Act of India, there is the government can intervene and they can check whether the company which owns the patent, are they providing it to the public or not? Are they working the invention first of all in India or not? Are they making it available to the public or not? And then are they doing it at a reasonable price point? This is something that you cannot squat on. This is something that saves lives. So you have to make it available reasonably to the public. They are failed on all these 3 tests, and the Indian government intervened and gave compulsory licenses that, okay, this cannot happen. The world needs what you have invented. And companies like pharmaceutical companies, it is not their money that they're using. Eventually, this all comes through a tax structure where they get rebate on it, where it is finally taxpayers' money. Some countries, taxpayers' money that is being used. So, and NATCO pays 6% royalty also to Bayer. But the point is that the government in life-saving threatening situations can intervene and make sure that the drug is easily available to the general public. Happens in the case of pandemics, happened in the case of COVID-19 as well. People cannot squat on these things. Similar things have happened with diabetes management drugs as well. That is unique, very much unique to India. And every time the government changes in the US, even today we closed, I think, a trade agreement with UK. The main bone of contention was one of these things, that India should stop this compulsory licensing activity. India should stop generic things. But we are in the right and they are in the wrong. Right? This we can explain. And finally, so, okay, IPR is there, invention is there. I told you it is there to advance humanity, it is there to advance sciences, and it is there to help humanity. And innovation always is done so that people get access to better and better things. But what do we need, right? Why do we need innovation? What are the three basic things that we need as humanity, right? Like in Hindi movies, it's a roti, kapda, makan, right? But kapda is okay, easily solvable. You can wear anything and you will survive. So it is food, shelter, and life, right? What happened? Food we have not solved, okay? Shelter also, maybe we have not solved. If we would have solved food, you would not have seen climate tech. A lot of deforestation happens because we want to provide food to the rising population, which amounts to climate change. So food we have not solved. Shelter also across the world we have maybe not solved. Life expectancy or life age we have solved to some extent. In the last 100 years, there was no concept of 100 years ago to 150 years ago, there was no concept of grandparents. People would never see their third generation. Now we have reached something called as longevity escape velocity. This was a term coined in 1970s, but published in a paper in 2004, where we are saying that with every year, we are increasing life expectancy more and more, right? So by the time you reach 100, your life expectancy will have reached 150. So we have already reached a life expectancy of 75.5 in 2007. Today, we are talking about a life expectancy of 100. In the next 5 years, we'll talk about a life expectancy of 150 also. Quality wise, not sure, but amount wise, quantum wise, yes, we are there, right? So grandparents are a relatively new phenomena. Does that make us develop? No, I talked about developing versus develop. So does this make us develop, that we have solved this? This is the final question that I want to leave you with. That okay, all this was there. And develop versus develop, I told you I'll give the answer, right? We have been talking about, we'll be reaching it. So from an IPR perspective, I'll tell you what does developing versus develop mean. Finally, as a country, we have reached a stage, and I talk about it from a practitioner perspective, where we have started fighting about intangible aspects. Street vendors also come to me with design infringement issues and ask me, ki ye lunchbox banaya kya? We are getting infringement threats of. If we have started fighting about, moved away from physical property fights and started talking about intangible property rights, that according to me is the mark of a start of the mark of a developed nation, right? So we are entering that domain, that now we are done with physical fighting. We are going to talk about intangible fighting, right? In the virtual worlds and whatnot. Pay real money, but talk about intangible aspects. So maybe we are there, or maybe we are reaching there. But this is the final question that I will leave you with. Yeah. We can take questions.
Thank you, sir, for such a wonderful talk. I hope you have got in detail the idea about the intellectual property rights. So anyone from the audience, if they have any questions, audience, those who are online, can also post their question on the chat box. And students, if you have any questions, you can ask him right away.
Individuals can also donate, institutes can also donate, combinations of legal entities, depends on what if you are employed by Google, you will not get paid. But then companies like IBM, you will own everything, but they will give you a one-time sum of your $10,000.
Any other questions? So currently in the chat box, we don't have a question, but as and when if you have questions, we'll direct them to you. Thank you, sir. Yeah. Legit.
Yes.
Going ahead with the session, we have our next speaker, Mr. Pratik Hendre. Sir is currently an assistant controller of patent and design in the Indian Patent Office at the Chennai branch. Sir is by profession is a biomedical engineer. He had been working as an examiner of patent and design since last 7 years and is currently working as an assistant controller since past 1 year for the patent and design in the Indian IPO office Chennai. I welcome you, sir. Today, the sir will be talking about introduction to different types of intellectual property rights. So,
Hello, am I audible? Hello.
yes, sir, you're
Am-
audible now.
yeah. Good morning, everyone. And first of all, happy IP Day to all. MGM College gave me opportunity to give some inputs about intellectual property rights to all the students. So without wasting your time, I'm starting with my first slide. So this is the logo of IP. My slides is visible, ma'am?
No, sir.
No.
No. And so you have shared the screen? Yes, sir. Now the screen is visible.
So from this slide,
So from the second slide.
yeah, from this slide,
Yes, intellectual property India.
yes, intellectual property India.
Yes, yes.
Is it slides are moving?
Yes, yes, the slides are moving.
Yeah. Okay. So this is the logo of IP, that is intellectual property of India. And in this logo, this is one of the small symbol. Can anyone tell me this symbol belongs to? What is this symbol? Anyone? Those who are online, they can answer.
But I guess no, because
Okay. So this is a symbol of your brain. So everyone having a brain, it is a gift of God, and you are making by using your brain anything that comes as an intellectual property. Any new idea, any new name, logo, symbol, any new invention, any new process of making anything, any new device, any story, any poem, that all comes as an intellectual property. So you are from medical background.
yes,
If
sir.
you are making any,
Sir, most of the students are from the medical background.
yes, yes. So you are from medical background. So you are aware that what is the importance. The earlier topic was the importance of IPR in healthcare. So the Chirag sir already covered many important points related to healthcare point of view. But I am giving just brief idea about what is intellectual property. So this is next slide. Is it visible? In this slide, it is showing in this slide you can find India's ranking is increasing from 81 to 40. This is a World Intellectual Property Organization's Global Innovation Index rank is given. So as per 2022, India is on 14th rank, but in 2015, India was on 81st rank. So definitely the growth or increase in our number is there. But why India is on 14th rank? As per population, India is the first rank. As per GDP, around fourth or fifth number. As per area, India is seventh largest country. Then why India is not in first 10 or first 20 related to an invention or intellectual property? The main reason is that lack of awareness about intellectual property rights. That's why India is not in first 20 related to invention or intellectual property.
Hello. So,
India is lacking behind as compared to Prime
sir,
Minister Modi ji. Have
so your screen sharing is being turned off and we lost you in between again. Yes, now it is good. Yes, sir. Now it's visible.
so our motto is to be in first 20 in coming 2 to 4 years. Now, what is creation of minds? As I have told, whatever you are making by using your brain, that comes as intellectual property. Means you are creating new things. It can be any name, symbol, logo, slogan, image, that all. Also some traditional knowledge. You may be aware about TKDL, then new product, any new process, any literary or artistic work, any musical tone, any photography, any drawing, any shape, any patterns, that all you're creating by using your brain, that all comes under creation of minds. And for that all creation of minds, you can file for creation of minds, you can file for intellectual property rights. So this is the umbrella of IPR. Under this umbrella, there are many different IP rights mentioned. First is patents, design, trademarks, copyright, geographical indications, trademarks, SICLD, that is Semiconductor Integrated Circuit Layout Designs, trade secrets, protection of plants and varieties, and farmers' rights. These all comes under IPR umbrella. So we are going to discuss these all IP rights one by one in coming slides. Now, what is intellectual property rights? Your principal or your HOD gave certain topic for project, and they ask you to make a report for that topic. So you start to think from your brain, right? So once you started to think from brain, the first step started. Then you are thinking, you are making a framework or any map about your invention or about your report, project report. So that is all process begins from your brain. Then you start to find resources like help from colleagues, friends, your teacher, then study material, internet, that all comes as a resources. And when you combine this all together and your actual working, so that gives you your final project, and that is output, is your project. This is same as intellectual property. In intellectual property also, creation of minds or any new idea comes from brain. Then you are making a framework or any structure in your brain. Then you are using resources and giving a final output for that product or device. So that is comes as a intellectual property. Now, what is the importance and significance of IP rights? You can protect your rights for your own self. Also, you can exclude others not to use that without your permission. And third, an important thing is utilize that for commercial earning purpose. So if you're having IP rights with you, you can get benefit from that. Next slide, it is explaining how can you utilize or commercialize your IP rights. First, you can use that IP rights for your own self. You can use for your own use. Then you can give license or assign rights to the person who are interested in same business. Next option is franchising. Example is McDonald. The owner of McDonald is not going everywhere. He's just giving franchises to the person who are interested in same food business. Another example, Yevleti. Owner is not going everywhere. He's just giving rights in the form of franchisee. Then next is merchandise. Example is Disney. So by this all four ways, you are getting more and more earning. So this is the importance and the way of utilization of your IP rights. Now there are two type of perspective related to IP rights. First is if you're having any IP rights with you. First is common person perspective. Second is businessman perspective. For common person, they after getting any IP right, they feeling pride. Yes, I have this patent or trademark, copyright, whichever IP rights. Then they are showing that in academics, taking a printout, putting on wall or any social media. That's it. That is the only common person perspective. But businessman, once they got any IP rights, they start to make commercialize that product. Once that products get commercialized, They are not stopping there. They're trying to make that product as a brand value. Once any products get a brand value, from that brand value, they start to earn more and more money. Now, again, they are not stopping there. From that earn money, they are again investing some part in new research, new invention, new IP rights, new commercialization, new brand value. So that cycle goes continuously. And that's the reason businessmen getting more and more money or monopoly in their field. So if you're having IP rights with you, you should think like a businessman. Now, our first IP right is patents. So can anyone tell me what is patents? Your previous session was related patents only, and today's IP day. So you must know. Anyone? What is patents? You don't know?
The right that is being provided to an inventor for their innovation.
Okay. Uh, good. So patent is an exclusive rights given to for invention or specifically any product or any process or method for that device. So this is sovereign rights given by sovereign authority. In our country, only government of India is the sovereign authority. No other private company or organization can give these patents rights to you. This monopoly rights given for 20 years. Its term for patents is 20 years from the date of filing. And the patent rights are territorial in nature. Means if you get patent rights in India, the boundary you can use that rights is only Indian boundary. If you want to enjoy that rights outside India, then you have to file separate application in that particular countries. These are the some of the famous Indian inventions. First is nano car. You all are aware that Tata provided an opportunity to middle class people to get a four-wheeler car in the budget of two-wheeler bike only. And this is very good invention. Then hepatitis vaccine, Jaipur food. Jaipur food cost in India around 3 to 4 thousand rupees, but similar Jaipur food cost in USA around 5 to 7 lakh rupees. So we are fortunate that there are many Indian inventors which giving good invention and in very reasonable prices, so that we can use that. Next is baby shower cap. You all are knowing that अगर छोटे बच्चों की आंख में पानी जाता है while bathing, they gets irritated. Inventor uses creative mind and make a zigzag shaped cap, and that's giving solution. Then wristband projector. You all are aware about auditorium projector, cinema hall projector, but this is a wristband projector. It can project any data, any information from your wrist or palm. Then micro card reader. You can connect that connecting chip to your phone and do a transaction easily. Then drone system. Drone is useful for photography, videography, surveillance, defense purpose. Then farmers also using for spraying pesticides. Now recent drone is such advanced that they can carry one people from one place to another, which having capacity of carrying around 90 to 100 kg. So in each field there is always technological improvement by 5 to 7 years. This is Graham Bell's phonogram. Then this is Wright brothers flying machine. This is Thomas Edison's light bulb. So these three was by famous scientists. Now these two are the simple one and very useful. This is a cord separator. Then bendable power strip to adjust in smaller space. This bendable power strip is very useful. As I told, there is always technical advancement in each field. You can find earlier there was a mini SIM card, then micro SIM card, then nano SIM card, eSIM. So always there is a growth and new invention coming in same field. Similarly for communication evolution, you can find. My slides are visible, right?
Yes, sir, they are visible.
Yeah. Okay. So this is the evolution of communication system. Now there are some things which are till now we have discussed which are patentable things. Now there are some things which are non-patentable in India. First and important from medical point of view is method of treatment and diagnosis or therapy method specifically is non-patentable. Then method of agriculture, horticulture is non-patentable. Any computer program per se is non-patentable. Any frivolous things, if anyone is claiming that from MGM college to New Delhi, they are reaching within 1 second, practically today it is not possible. Such frivolous things are non-patentable. Now, in this slide, you can find this person. His name is George Alfred Depenning. He was the first person in India who received patent. He received patent in 1856. Means India also having very long history about patents. His invention was an efficient pankha pulling machine, and he was an civil engineer. Now you will think that for patents it is required to have engineer only or to have very big research only or scientific data only. If you having scientific data and research, that is a well and good thing. But if you have solution to particular problem, then also you can get patents. Because in next slide you can find it is a simple paper clip. This paperclip received patent in 1919, means at the time of First World War. This inventor uses creative mind and gave a bending. He used a wire and give a different shape to hold the set of paper, and that gave solution. So that paperclip also received patent in 1919 from USA. You all are knowing him. He is Michael Jackson. His shoes was patented one, and he himself was the inventor for that. He made a special groove on his sole that was helping him to do an anti-gravity move while his dance performance. He received patent from USA in 1993, and he was the inventor for that his invention. Next IP right is design or design patents. So design, it's an ornamental or aesthetic aspects of an article, which can be in the form of shape, configuration, patterns, combination of lines, colors, and which can be judged solely by your eyes. If you are able to distinguish two different designs, then that comes under design patent. The term for design patent is 15 years. You can find different shapes, mineral water bottles are there in market, but each company is trying to keep their design as unique as compared to their competitor. Similarly, different shapes, mobile, laptop, that all comes under design only. Nowadays, many products comes in Tetra packs. So each company trying to keep their design as unique. Similarly, different, you all are knowing, or there are many brands biscuits in market, but none of the brands biscuits are same or e- exactly same as to another. The reason is that they all are registered under design patent. Now if you're having more than one product with similar category, then you can file as a set of design or set of articles. Example, sofa set, jewelry set, crockery set, knife set, that all comes under design patent. This is single product, but having different designs. So you can, by this example, you can easily understand what is design pattern. This is pencil only, but each having different shapes, pattern, color, combination, different shapes, toys, ornaments, combination of lines, colors, that all comes under design pattern. Next IP right is trademark. Trademark is a sign and symbol which is capable of distinguishing the goods and services from one enterprise to another. Can anyone tell me this symbol belongs to which brand?
So the audience have answered as Nike.
Okay, good. This one,
Puma,
this one.
Domino's,
Okay,
McD,
this one, MACD.
Hindustan Unilever,
Yes, this one.
Apple.
Yes, this one.
So which one are you asking?
This yellow
Flipkart.
one. Flipkart. Okay, so you can see I have purposefully removed names from their logo, but till you are able to identify the brand or product from that logo only. The reason is that they are registered trademarks. So that is the power of the trademark. So trademark is the subject matter which comes under trademark is brand name, tagline. Example, Nike, just do it. So Nike is the brand name, that arrow symbol is a symbol, and just do it is a tagline. So that all combined comes under trademark. Then certification marks like BIS mark, ISO mark, that can be a part of trademark. Then sound marks, just Britannia's ting ting ding. Just by listening this tone, you can identify this is tone related to Britannia. So that all comes under trademark. Then logos, different combination of colors, lines, that all comes under trademark. So trademark is a sign and symbol which is capable of distinguishing goods and services from one enterprise to another. And the term for trademark is initially you require to register for 10 years, and after that you can do renewal indefinite time. In market, you can find deceptively similar trademarks like Puma as a Coma, Nike as a Nuke, Starbucks as a Sardar Bucks Coffee and Company. But if you have been a registered trademark with you, so it is your own responsibility to be aware and vigilant that no one can copy your trademark symbol. You can find different versions of Adidas also. So it is your own responsibility that no one can copy and fool people. Now, how can you identify this product having registered trademark or not? So R mentioned on in circle, that means that product having registered trademark. And TM mentioned on any product means they have filed for registration but yet not received. Next, IP right is copyright. Copyright is an uh, legal rights given to creator for his literary work, artistic work, musical work, cinematograph films, sound recording, computer programs, that are the important categories. How can you find that any specific product having registered copyright? So C in circle means that product having registered copyright. Copyright is a legal term describing rights given to creator for his literary, artistic, musical, dramatic, cinematographic works and sound recordings. Copyright is a bundle of rights, and it is automatic right and moral right. Copyright cannot protect an idea. Suppose Sachin having uh, one story idea in his mind that ABCD is a character, PQRS is sub character, and so on. That story's plot is in his mind. He have not told to anyone, not written anywhere. Similar story, if Virat disclose first or tell anyone first, that I know one story, it having ABC character and this PQRST is sub character like that. But he disclosed first or mentioned or written down somewhere. So first right given to Virat because he have expressed his idea. Sachin having idea in his mind only, he have not expressed that. So copyright cannot protect an your idea. You have to express that, then only you can get that right. Copyright is an exclusive legal rights given to creator for the expression of an idea. Copyright owner can reproduce, translate, adapt, perform, distribute, and public display of his work. Registration of copyright is not mandatory, but for legal enforceability, it is more recommended that you should register your work under copyright. Because 2 3 years back there was a case related to copyright that Shah Rukh Khan's film Fan was challenged due to copyright issue, where uh, one of the writer was saying that that story from that Fan movie is based on his novel, but he was legally not able to prove that how that book. Uh, I think there was some he have not filed registration or did copyright of his book, so that's why he legally not able to prove that how that story went to director of that movie and so on. So it is more recommended that you should register your work under copyright. These are the sections where you can file for copyright. First is literary work, paintings, photographs, drawings, films, music, choreography, sculpture. So literary work, it can be a novel, story, poem, any news article, any study material, any computer program. That all comes under literary work. If you anyone is good in painting, photography, or drawing, they should register their work under copyright. Now, what are the terms for copyright? If I'm the author of any book, I will enjoy that copyright rights for whole my lifetime. After my death, my legal heir will enjoy more 60 years. About films or songs, the term for copyright is 60 years from the date of publishing. Now, next is broadcasters' right. Broadcasters' rights example is Kapil Sharma shows. The broadcasting rights of Kapil Sharma shows is with Sony TV. So no one competitor can telecast that show without Sony TV's permission. Similarly, Z Saregama, Z Antakshari, the all broadcasting rights is with Z TV. So without Z TV's permission, no one can telecast that show. They can telecast that show n number of time as per their wish because they're having their rights. The term for broadcasters' rights is 25 years. Next right is performers' right. Performance means actor, singer, juggler, musician, puppet show, the person who are performing their art. The term for performer act is 50 years. This is a case study, a famous case study about copyright. This is a famous case study related to copyright.
Sir, just a second. I guess your screen. Yes, now it's shared.
In this, there is a one wildlife photographer, David Slater. He went to African jungle and he purposefully kept his phone in that jungle forest. One black ape, this monkey, came and took that phone and captured his selfie from that phone. Due to Google backup, he received that photo. Now Wikimedia magazine came and they published that photo without David Slater's permission because they were saying that photo is clicked by monkey, so the copyright for that photo is with that monkey. David Slater said, photo captured by my phone. So copyright should be with me. Then that case went to US court. In between, PETA also came that we are working for the welfare of animals. The copyright should be given, or the money earned from that photo should be given to us. And US court gave a special judgment that copyright cannot be given to any animal, and the money earned from that photo is given for the welfare of animals. Similarly, another famous case study is Rameshwari photocopy book. In this, there is one Xerox center at Delhi. They were used to give Xerox copy of famous authors or books related to study material only, like Oxford or other uh, university books only. Then they filed a case against them for infringement under copyright. But Indian court gave a special judgment that Xerox book center is not giving complete Xerox of full book. They are just giving some part or some pages from that your book. And if it is for educational purpose, then there is no copyright coming in between. So this is the famous case, Rameshwari photocopy case. Next IP right is geographical indication. Now सभी लोग मेजोरिटी लोग चाय पीते हैं. चाय कहाँ की आती है? मोस्टली आसाम टी और दार्जिलिंग टी. Currently summer season is going and people eating mangoes, and they are preferring mangoes from Konkan region, that Alfonso, Konkan Alfonso. Similarly, if people going in market to purchase orange, they specifically ask, is it a Nagpur orange or not? The reason is that no one is asking Patil Sapus or Shinde's mango, or similarly for orange also. They're asking Nagpur orange, Konkan Hapus, or Darjeeling tea, or Assam tea. The reason behind is that this product has special tag under GI, that is geographical indication. The geographical indication is a name or sign used on products for uh, due to its special qualities and special labor efforts from that local region. Examples is Tezpur lychee, Mahabaleshwar strawberry, Chanderi fabric, Ambe Mohor rice. Darjeeling tea is the first registered GI in India. In India, there is more than 400 products which having this special tag. Sulapuri chadar, Sulapuri terry towel, Puneri pagdi, Nashik Valley grapes, Paithani sari, Warli painting, Kolhapuri jaggery, Kolhapuri chappal, Sindhudurga kokum, then Makrana marble from Rajasthan. The marble which was used for the making of Taj Mahal is from the place is Makrana from Rajasthan. So that Makrana marble is also registered under GI. Then Ratlani save, Kanchipuram silk, then Rajasthan Katputliya, Bagh prints, Bengal Pat Chitra. So this was related to GI. There are some products from Maharashtra like Lasalga onion, Vengurla cashew, Wagya Gehuda, Sangli resin, Bid custard apple, Jalgaon brinjal bari. So you all are knowing many products. Recently, 2, 3, I think a white onion from Alibag also got GI tag. So this GI or geographical indication tag given for products due to its local environmental condition and local labor's efforts. This GI tag can be given for the group of people, not for individual. Previous all IP rights was given for individual basis only, but this GI tag is given for that specific village or the region, geographical region. For from their association, they are giving these rights. Next IP right is semiconductor integrated circuit layout design. Now you are thinking that we are from medical background. What is the use for this SICLD? So the device you are using for any therapy or treatment in medical industry, which having a PCB structure, and that layout of that PCB is registered under this SICLD. You can find these are the PCB board and these are the devices. Specifically in electronics, IT, and biomedical field, this SICLD they are filing under a registration. The term for this SICLD right is 10 years. Now there is one more IP right is trade secret. The recipe of Coca-Cola or the recipe of Big Mac sauce is protected under trade secret. So trade secret in which the secret of that making or recipe they have kept secret only. They have not disclosing to anyone, and that's the reason they are enjoying monopoly. Similarly, the algorithm on which Google works, that Google algorithm, because why people preferring Google due to its fast result and accurate results. It is based on that one specific algorithm they have kept as a secret. That's the reason they are enjoying monopoly. So these are the some of the important IP rights. If you want to get more information regarding these IP rights for specifically patents, design and trademarks, you can visit this ipindia.nic.in. Then for copyright, you can visit copyright.gov.in. Now, in earlier slide, I mentioned that you should think like a businessman if you're having IP rights. The reason is that I'm showing in this slide. This is a Apple MacBook. In single product, they are enjoying multiple IP rights. First, the LED display, they have patented one. This logo of Apple, they have registered under trademark. The body design is registered under design patent or industrial design. The user manual of this MacBook, they have registered under copyright, and internal layout design is registered under SICLD. So single product and multiple IP rights. And that's the reason they are enjoying monopoly in market. So this is all about IP rights. So there are many things to cover related to IP, but I'm not taking more. This is a basic thing about uh, different IP rights like patent, design, copyright. Different things like different IP rights like patent, trademark, copyright, and GI. So there are some courses also available regarding patent drafting or patent filing from NPTEL or IIT Incorporation of Government. So if you are interested, you can join that. Also, you should file for patent or different IP rights if you're having any new ideas, new technique, new invention with you. So that can be helpful for you also, for
Sir,
our
this is
society also. Yes, ma'am.
Pratik, sir. Can you hear
Yes,
me? Yeah,
yes,
this
yes.
is Victoria here. Since Chirag Tanna sir is also here, so we would request you to just stop the share screen and only increase your screen so that we can click a
Okay.
picture with the students as well. So you in the
Okay.
frame behind. Yeah, yeah, perfect. Yeah,
Okay.
thank you so much.
So thank you, MGM. Thank you, Neha ma'am. Thank you, my family, Ridan, Pranali. Thank you, all students who have
Sir,
listened my session
sir,
patiently.
Sir, can you hear?
So
sir,
thank you again.
so we'll be continuing with your talk. It's just that the sir has to leave for
Okay.
another meeting. So just one quarter, then we continue. Thank you, sir. So we can continue with your session.
This time is there.
Hello, sir, can you hear me?
Yes, yes.
Yes, sir, you can start. Yes.
So thank you everyone. Thank you for giving me opportunity on this IP day for giving some basic inputs related to intellectual property rights. If anyone having any doubts, you can ask.
Okay, thank you so much, sir, for taking out some time for us and giving us an overview of different types of IPR rights. I hope this session was very informative for all the students over here. Any questions from the audience are welcome. So we have a question from Dr. Victoria, an assistant professor at MGM School of Physical.
So maybe when the institute is involved, so even I'm a PhD scholar here.
Okay.
So if the institute, so what we do while patenting or anything, it's in the institute's name. Okay, so
Okay.
when it's about to commercialize,
Hmm.
when the product is ready to commercialize after the prototype and everything, like all the testing validation, and we are in the first stage of like pilot production, post that we commercialize, right? So in
Yes.
that, how would the investigators, so there are 4 to 5 investigator per se, so how would the investigator with respect to devising that, but since the institute has helped in devising that, so the name would be institutes, but the
Yes.
investigators will be 4 or 5 individuals, okay, from different areas. So
Yeah.
with respect to this, if it is going to commercialization, what would be the profit the investigators as well as the institute would gain?
Uh, Actually, Chirag sir also will give their
Yes, yes,
inputs on this point.
yes.
My thing is opinion is that it is your mutual agreement. You are giving rights. The inventors giving rights to applicants. So how you are making their agreement that whole rights given to applicant or the some percentage,
Okay,
what are that share? It is your agreement. It is based on your agreement only.
okay. So it's between the
Legally
institute
it,
and the
yeah,
investigators.
legally
Okay,
equal rights should be in between there, but
okay,
it is based on your agreement. So
okay.
Chirag sir, I think
Yeah,
will give more
yes, yes,
inputs
yes.
on
Yeah,
this.
he is there, collaborated with us already
Yeah,
for one of
yeah,
our
so he will
patents.
give
He is an
more
attorney.
answer.
Yeah. Yes, yes. Thank you so much, sir. Students, you all want to raise? I can ask in behalf of you all. Yeah. So someone wants to say?
Ma'am, you are not audible. You are mute.
So, sir, there is a question from an attendee. Are patents impeding medical care and innovation?
Uh, Generally, it is not impairing. If uh, the applicant is not doing a monopoly and keeping the rights in prices in higher range, then only it will affect or impact. As Chirag sir also mentioned in that compulsory licensing example, if any specific case is there, in some specific case only it can be happen, but normally if you are filing for device or system, it is not impacting. If only method of treatment is there, or method of diagnosis or method of therapy, then only it is giving some restrictions to other users, but that is non-patentable as per Indian Act. So I don't think it is impending. It will be helpful for applicant and for user also to get uh, explore that other all opportunities whichever available.
So I think such cases wherein patent laws are not applicable, we can apply for copyright. If the
Yes,
methodology is something
yes,
novel,
yes,
we can go for copyright, right?
yes, definitely.
And any questions? Okay, so sir, our NPT scholars, our master students, had a query on update on recent Data Protection and Legislation Act. So in how many years does it get updated and where will we find that?
Ma'am, that is not related to patent firstly,
Yeah,
so I can't comment on other policy matters.
okay, okay. So just, are you asking about participant data protection? Recent data, in what terms? In terms of IPR, any other intellectual property, copyrights? So we are just getting clarity on the question. Meanwhile,
Okay.
attendees, if you all have any question, you can post it in our Q&A session. Anyone from the audience who have a question, questions on trademarks, copyrights, or any other IPR? So, so sir, they needed a clarity on a recent patent act.
The year, basically the year, sir,
Year,
the year which we followed, the acts year.
Okay, what clarity wants?
Indian
Means what
Patent
is
Act, the
huh?
recent act that is being followed in India.
Yes,
Okay.
yeah. It is
So,
just amendment happened in 15 March 2024. But
okay.
in that context, what is exact they want to? What is question?
So they wanted to know the act and with respect to the data. So data in the sense it can be any device or anything with respect to any human specimen or human participants or any data with respect to patent. So I think that doubt is cleared if you have shared 15 March 2024. So in
Yeah,
that
it is
law,
just
they need
it
to
is
check
just
whether
it is 15
data
March
protection.
2024. It is published or open for all public.
Yeah.
From that amended act only, the further proceedings will start now,
Yes.
and it is available on internet also,
Yes. In
on
the
official website also, that amended rules and new points which they have, new rules they have introduced, that all are available there. So it is open for everyone now.
Thank you, sir. Thank you, sir.
So, sir, you have answered all the questions. Thank you so much for giving your precious time to us and connecting us to the IPR rights on this World Intellectual Property Day. Thank you for your time, sir. Thank you.
Okay, thank you everyone.
On behalf of MGM School of Physiotherapy and Omics Center, so we are very grateful that you shared your knowledge to our students so that they inculcate or they apply it whenever they are ready to commercialize, or at least in the prototype designing. So wherever applicable, your insights and knowledge will be really helpful for them as well as us as faculty. Thank you so much.
So we conclude the meeting today. Thank you, sir.
Thank you.